Former state attorney Harry Shorstein speaks out about crime and punishment here on the First Coast. Good morning, live from Studio 5. This is First Coast Connect on 89.9. Thanks for listening. I'm Melissa Ross, and a busy program coming up later in the hour. It's a new event here in town, and demand is so great, it's already sold out. We'll have details on Jacksonville's first ever Food Truck Championship. It's coming up on Saturday. Also ahead, the nation's atheists meet in Washington for a big event called the Reason Rally. We'll speak to a local non-believer about that movement. And Jacksonville Magazine's Carrie Speckman has our preview of all this weekend's events. That's later in the hour. All of that ahead. But first this morning on the program, he's kept a low profile since leaving public office 3 years ago. Now, former state attorney Harry Shorstein is speaking out about crime and law enforcement on the First Coast, and he has concerns. This morning, he discusses the handling of the Christian Fernandez case, juvenile crime in Jacksonville, and more as he takes your calls. Harry Shorstein, welcome to the program.
Thank you for having me.
Thanks for being here. And what are your questions for former state attorney Harry Shorstein? The lines are open. Give us a call. 549-2937. That's 549-2937. Send your emails to firstcoastconnect@wjct.org. Tweets to @MelissaInJax. And Harry, you've gone into private practice since retiring from the state attorney's office. Haven't really done a lot of media interviews in the last few years. However, there's a lot to discuss. And as you and I talked the other day, you said you felt the need to speak out. You have some concerns about the way crime rates are going in this area and the way your former office is being run. Why did you feel the need to go public with these concerns?
Well, we worked very diligently to develop a comprehensive juvenile program that combined punishment with prevention and early intervention. And I think it brought international acclaim to Jacksonville. It was reported throughout the world and pretty much adopted in other jurisdictions. All of that has changed, and it's very, very sad, and I think it's had a seriously negative impact on crime.
Your successor, Angela Corey, has gone about treating juveniles in the system in a markedly different way. Why in your view, is her approach not the way to go?
Well, and it takes a little while to explain, but when I became state attorney in 1991, there was tremendous attention about juvenile crime because it was increasing significantly. Excuse me. There were two major studies done in the very early 90s, one at the University of Florida by Professor Chuck Frazier and Donna Bishop. It's an outstanding study and very similar to another one done in the Northeast. And what they said is, don't just send juveniles to adult court. And if you do that, you're really increasing the potential for further criminal activity because, one, you brand them with an adult record. Two, you put them in an adult criminal environment. Three, you give them the feeling the society has given up on them. And four, if you put them on probation, you should have left them in juvenile. So we were already doing that, and they all called and said, well, what do you think about the study? I said, I agree 100%. What we did is we withheld adjudication of guilt, put them in a special program in the jail that had everything from school to mentors, learn to read, arts assembly, Toastmasters. It was an outstanding program, and as a result, juvenile crime plummeted. Now we're just sending them to adult court. And the problem with that, among other things, is when you send them to adult prison, they're going to get out at still a very early age and then have a life of crime because they'll have no other alternative.
The most high-profile case involving a juvenile, of course, is that of now 13-year-old Christian Fernandez, the youngest murder defendant in city history. He has been charged as an adult. Angela Corey was on this program yesterday, and here's what she had to say about her approach in the prosecution of Christian Fernandez.
What we're looking for with Fernandez is middle ground. I've said it over and over and over again. Middle ground between what juvenile offers, which isn't sufficient to handle the issues in this case, and adult court, where life in prison will not be an option for Christian. Whether we try him or don't try him, I am not looking for life in prison on Christian Fernandez.
Okay, so she's saying she's trying to find a middle ground for this young defendant. She's saying the juvenile system isn't adequately equipped to handle this case. What's wrong with her explanation there?
Melissa, not only was that explanation erroneous, she's made a number of statements about the Christian Fernandez, which frankly shouldn't have been made by a prosecutor while the case is pending.
Such as?
Well, a number of untrue statements. The first is that she has never said, she's repeatedly said she never suggested that the child was guilty of premeditated murder. That's what he's charged with. The indictment reads with premeditated design to effect the death. Then she said, never intended for the child to get life in prison. There is only one punishment if the child were to be found guilty. The judge would have no alternative but to give the child life in prison. She said that she cares about the child and the child's welfare. That child was in solitary confinement, isolation in an adult prison, the Duval County Jail, until the defense attorneys moved to remove him to juvenile court. And she objected to that, but Judge Moran ruled that the defense was corrected. The child now is back in juvenile court. Most importantly, she said yesterday, the child couldn't be left in juvenile because the maximum time that a child could be held in juvenile is 3 years. And that's just absolutely incorrect. If the child were put in what we call level 10, which is the maximum risk, that facility accommodates juveniles for 3 years. But the juvenile could be placed in another juvenile facility and kept to his 22nd birthday. She keeps saying that, and to my knowledge, she's never confronted or consulted with the Department of Juvenile Justice. I did. And all it would take, if you want to debate this issue, would be a phone call to the General Counsel of the Department of Juvenile Justice. So the child could be kept from age 12, since that was when he was incarcerated, to, I think it's his 22nd. It could be his 21st birthday, but we're not talking about a limitation of 3 years.
And if you're just joining First Coast Connect, our guest this morning, former State Attorney Harry Shorstein. We'll get to your calls in just a moment at 549-2937. Let me ask you this. For those who strongly support Angela Corey's methods and approach, they might say to you, look, Harry, your former deputy, Jay Plotkin, ran against Ms. Corey and lost. Is this just sour grapes on your part?
Well, Melissa, as you pointed out at the start of the discussion today, I've really tried to avoid any talks, complaints about Ms. Corey for over 3 years.
For 3 years, you haven't done any interviews that I'm aware of.
I've tried to dispel the rumor for the last 3 years that I'm retired because I'm practicing law.
You're retired from public life. You're still practicing law.
But yeah. I've done that. But it's allowed me to interact with the criminal justice system, with the state attorney's office. Before we leave Christian Fernandez, though, if we're going to, can I just talk for a second about what we learned over the years that I was state attorney, because I was on an advisory committee for the Department of Justice on juvenile justice, and there was tremendous research on the development of the adolescent brain and legal culpability of young people. Generally, and I know you've had Dr. Goldhagen, who's much more knowledgeable than I, on but there's so much written and almost no disagreement that the adolescent period they're talking about is generally from age 10 to 22, 23. This child was 12. So the two factors that would lead to a determination of his culpability are, one, his environment, which much has been spoken about, the fact that he was born to a 12-year-old, that his stepfather killed himself in front of the child, that the child was severely abused. But more or equally importantly is the development of the portion of the brain that deals with your behavior. And again, the frontal lobe of your brain, the prefrontal cortex, which I understand is right behind your forehead, controls your control of your behavior. And this is just starting to be developed at age 12. So the only other thing that the child could rely upon other than normal development is his environmental development, which from everything that's been reported was absolutely horrible.
And so given all of that data on brain development and the background of this case, it seems that in particular you feel compelled to speak out about this case. the Fernandez case, the way it's being prosecuted.
Yes, I think it's absolutely wrong. Another example, prior to the criminal case, when the case was in dependency, the state attorney asked to have Christian examined by Dr. Meadows, who's a local psychologist. And I think Ms. Corey said, I did that in order to gain information from which to make the decision whether or not to prosecute him as an adult. They gave Dr. Meadows all of this horrible background, some of which may or may not be true. And in spite of that, my understanding of Dr. Meadows' report is that the child is definitely subject to rehabilitation, and everything about a 12-year-old from the environment from which he came impacted on his behavior. So it's like I'm asking you as an expert for an opinion so that I can make a decision and then totally ignore your opinion, which is consistent with all of the science as far as I know.
All of these issues aside, Harry, as I mentioned, there was bad blood between you and Angela Corey. She left your employ under contentious circumstances. Your former deputy, Jay Plotkin, ran against her and lost. So what would you say to those who are listening to you now and say, well, he's casting aspersions and criticizing perhaps because he's still upset about the way things played out?
Well, as I said before, it's been 3 years since I've really spoken. Angela worked for me during my entire 5 terms until I did fire her.
And why did you fire her?
Listen, it's very, very well documented. She was fired for unprofessional conduct. It's very, very simple. We, as most state attorney and public defender's offices, have interns from the law school come to us so that they can help us, we can help them. When they leave, we critique them, and then they go back to law school, and they in the law school critique us so to determine whether or not they'll send us interns. We got a call from the professor at the law school who's in charge of the intern program and said that one of the students complained that Ms. Corey's conduct was profane, unprofessional, abusive, particularly abusive towards women. The professor reported that to our office, and I brought Ms. Corey in, and I said, well, that's a very serious allegation. She immediately called or wrote a letter criticizing the professor who relayed the message and the dean of the law school. And I said, well, that's absolutely unacceptable. The professor is merely delivering the message, which she should. I said, you'll have to apologize to the professor and the dean. And she refused. And I'm not trying to sound like a tough old Marine, but if you're given an order that's a legal order, and I think very appropriate, and you're not following my orders, one of us would have to leave. And I gave her that alternative. And she immediately, incidentally, filed a EEOC complaint, which was summarily dismissed. So the firing is very, very well documented.
And we'll continue to discuss that. But in the meantime, let's go to the phones. 549